Ma'am, it started.
Okay.
Ankita, you may begin.
Good afternoon, everyone. I'm grateful to you all for joining us today. I hope you all are doing well. Before we proceed, I would like to wish you all a very happy Independence Day. It's my privilege to introduce such a colossal institution on this auspicious occasion. I, Anikita Sharma, welcome you all on behalf of Advocate Sri Vasantrao Patil Lawyers Training Center, supported by Sangli Bar Association. Let's see few facts about the center. Advocate Vasantrao Patil's Lawyers Training Center was established in year 2019 in the memory of late Advocate Vasantrao Patil sir, who was an esteemed personality. He was a profound criminal lawyer and an ex-president of Sangli Bar Association. The intent of center is to reach out the young budding lawyers and facilitate their overall development by imparting legal knowledge, professional ethics, and legal conscience. With the essence of achieving this end, the center has till date arranged number of successful lectures of prestigious luminaries in the legal field. And today, it's our honor to have one of the eminent personalities of Kolhapur Bar, Advocate Dr. Santosh Shah, sir. Thank you, sir, for joining us today.
Thank you.
Now, over to you, Advocate Kedar Patil, sir, who will give you the brief introduction about our guest speaker. Thank you. Have a nice day.
Thank you. Dr. Santosh Shah, sir, has done MS in Political Science from Fort Hays State University, USA. He's also LLM from Temple University, USA. He has also done PhD in law. Dr. Santosh Shah, sir, stood first class first at the LLB final examination, and because of which he has won number of awards, including a gold medal. His name is included in the Dean's list of students at Temple Law School, Philadelphia. He is also a recipient of Stauffer in International Student Scholarship and
video on कर रहा
career transition at Fort Hays State University, USA.
असला कॉल
He
आहे
is also recipient of Certificate of Merit as an
Video
outstanding
start video
law
है की
teacher from the Institute of International Commercial Law, Pace University School of Law, USA. Sir started his practice in the year 1991. He was into the practice of preparing documents, conveyancing, etc. His clientage include Shivaji University, Kolhapur Central University, Rajasthan, Maharashtra State Board of Secondary and Higher Secondary Education, insurance companies, banks, Menon Group of Companies, Shaw Walls and Company, Central Bureau of Investigation, etc. Dr. Santosh Shah, sir, is also honorary professor in law at various institutions in India. He is guide and examiner of PhD students in law. Santosh Shah, sir, organized and participated in presenting papers and acted as a resource person in many national and international conferences, seminars, and workshops on law-related topics. He also published many articles in English and Marathi in various journals, newspapers, and online journals. Dr. Santosh Shah, sir, is a great orator. We hardly find any eminent personality like this having such a great scholarship in legal fraternity. We are highly privileged, sir, to have you as a speaker on this webinar. Thank you, sir. Over to you.
Thank you. May I begin?
Yes, sir.
Yeah. Good afternoon, everybody, and happy Independence Day. The Vasantrao Patil Institute of Sangli, I must say, is doing a great work because I have been following the webinars that are being held through you since lockdown, and I consider it as my honor to be invited here. I would like to make a mention of few people before I begin and start with my topic. First and foremost, Advocate Priyanka Patil, Priyanka Rane Patil, who took efforts to get me on board today. Her family members, Advocate Sudatta Patil, Advocate Kedar Patil, Advocate Pramod Bhakre, in whose, when he was the president of Sangli Bar, the center was inaugurated, I'm told. 2-3 other people who are also very important for me and who have again been responsible for getting me here. My dear friend since long, with whom I share family relations, Advocate Abhinandan Vagyani, his wife, Professor Deepa Vagyani. One more professor I would like to mention, she has joined from US, Dr. Vaishali Israna Bolivdekar, who is also a professor of law, who was in Pune and now she's in US and is doing, holding webinars on law-related topics for students. So by thanking everybody, I think I can start with the topic. Am I audible?
Yes, sir, you're audible.
Okay, great. Okay. In case there is some loss of connection or if I'm not audible, just let me know. I begin with the topic. My topic, as you can see behind the screen, is class actions, a substitute for PI. I'm sure you never had a topic of this nature in any of the webinars you had. The topics are normally straight on a particular law, analysis of a particular law, critique of a particular law, etc. So there's a reason why I have taken this topic, because I want to invite and encourage the members of the bar and the bench to seriously consider substitutes for public interest litigation. Now, why I say so, when I go on, I'm sure it will be clear. So class actions as a substitute for FIAL, or how you can bring public causes at local levels, at local courts, would be our focus. Okay. So as I go on, I think the concepts will be more clear. I will be dividing my talk into a few portions, and you will see only the titles of the topics which I'll be dealing with behind the screen. Okay. So let us first answer, what is the need for class actions, or why do you need, okay, class actions, or why do you generally have to think about this topic? Now, today being Independence Day, we all know that preamble to the Indian Constitution says, we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular republic, and to secure to its citizens justice, social, economic, and political. I'm emphasizing the words justice, social, economic, and political. And if we go to Article 39A, which is part of the Directive Principles of State Policy, what it says is also that equal justice should be the goal, should be a constitutional goal. Equal justice and operation of the legal system which promotes justice has to be our ideal. Now, keeping these two things in mind, I will just quote from two great judges what they have said. First, Justice Krishna Iyer, in his book, Equal Justice and Forensic Process, and I quote, he says, to introduce measures by which the poor and the disadvantaged are taught to combat exploitation and injustice, and to fight for their rights and entitlements by using law creatively and imaginatively is a constitutional obligation. So he says that we must use law creatively and imaginatively to help the cause of poor and disadvantaged people. So how we will use class action creatively and imaginatively is what we will see. Second important quote that I would like to begin with is Justice Bhagwati's committee on national judicature titled Need to Undo Pervasive Pessimism. And this is what Justice Bhagwati has said. To undo pervasive pessimism about the whole legal system, he says, we require public interest litigation, we require class actions, we require representative proceedings for redressal of wrongs and assertion of rights. So the need for class action has been emphasized. It is very much there in a country like India, and that has been emphasized by great jurists. With this, now I will go to the next part of the webinar, which is about introducing you as to what are class actions. Now, see, the term class actions is used in different legislations, or sometimes some different words are used. Okay, let us start with different legislations, and then I will tell you what will be my focus, because my focus will be limited to class actions which can be compared with public interest litigation. Okay, but let us understand where all class actions are there in Indian law. First and foremost, and this is going to be my focus, is the Code of Civil Procedure 1908. There are two provisions where class actions are thought of. One is Order 1 Rule 8 of CPC. And Order 1 Rule 8 CPC has been amended in 1976. Okay? And that's how class actions are introduced. The title of Order 1 Rule 8 is representative suits, and not class actions, but they are in fact class actions. So the focus of my talk will be Order 1 Rule 8. Then there is another very important provision of CPC, which is Section 91, which is relating to public nuisance. Section 91 of the Code of Civil Procedure. Let me tell you that both Order 1 Rule 8 and Section 91 of CPC are perhaps the most unutilized yet most effective provisions, and this is where my focus is going to be in this talk of mine. But as I said, let me also tell you where all class actions are used other than civil, other than the Code of Civil Procedure. You can take back the slide. Actually, introduction to class actions. Second part where class actions are used are class actions under Consumer Protection Act 2009 and even the Repealed Act 1996. If you see the definition of the word complainant in Consumer Protection Act, it includes a class action, that is one person filing a complaint on behalf of numerous persons having the same interest. The definition of complaint will tell you. Of course, in this talk, I will not go into it, but there is the concept of class actions in Consumer Protection Act, which is also not very frequently used. Then, if you remember, there was a scandal in this country of Satyam scandal. Okay, after Satyam scandal, the Indian Companies Act 2013 came to be amended, and Section 245 came to be introduced, and 245 also deals with class actions of members, shareholders, and depositors. Okay, that is another class action which is there in another legislation. Then another legislation is the Competition Act. In the Competition Act, Section 53N uses the word class actions in the Competition Act against those who violate the competition law. Then, very interestingly, there is class action which can be used even under criminal law. Okay, and for that, I would urge all of you to read Justice Krishna Iyer's judgment in Municipal Council Ratlam versus Vardichand and others, reported in AR 1918 Supreme Court 1622, where he has shown as to how Section 133 of CRPC, which is a section of public nuisance, can be used against a municipal corporation for laying of drainage scheme in a municipality where, due to lack of drainage schemes, lot of annoyance, lot of public nuisance is being caused. So even even criminal law can be used for class actions. And then there may be other legislations where you find that Order 1 Rule 8 or CPC is made applicable, maybe in other legislations, other tribunals, other adjudicating bodies, other authorities. Wherever CPC is made applicable in this manner, Wherever order 1 rule 8 is made applicable in this manner, class actions can still be imported there as well. Okay. So I think this is to just give you an overview of where all in Indian jurisprudence, Indian legal system, class actions are used. I repeat, in the limited time we have, my focus will be on class actions under CPC in comparison with PIL. The other class actions we are leaving out, at least now. And anyway, they may not relate directly to PIL, though they may to some extent. My focus is Order 1 Rule 8 and Section 91 of CPC. So let us now go directly to what are class actions under CPC, that is what are class actions under Order 1 Rule 8 of CPC. I will have to just read Order 1 Rule 8 and then explain, because as lawyers and law students, it is always good to read the actual text. Order 1 Rule 8, it is titled as "One person may sue or defend on behalf of all in same interest." So the title is "One person may sue or defend on behalf of all in same interest." Okay. It starts with this wording: where there are numerous persons having the same interest in one suit. Let us take a small pause here. It says numerous persons having the same interest. These are crucial for interpretation of the section. These are two main conditions: numerous persons and, most importantly, same interest. I will come again to these words. I'll come back to it, but these words may, please keep these words in mind, particularly word same interest. Okay. So where there are numerous persons having the same interest in one suit, A, one or more of such persons may, with the permission of the court, sue or be sued, or may defend such suit on behalf of or for the benefit of all persons so interested. What it says is any one of them or more than one of them can apply to the court that, look here, there are numerous persons, I am one of them, I have the same interest, please allow me to represent all these persons as their representative. So permission of the court is to be sought. Okay. We will, as I go on, I think things will be more clear. I will also give you examples. Second part of it says the court may direct that one or more of such persons may sue or be sued, or may defend such suit on behalf of or for the benefit of all persons so interested. One more thing which must be noted, that this applies not only to the plaintiff, even to the defendant. Sometimes out of the defendants, one defendant may come to the may apply to the court under A and say that all these defendants are numerous, they share the same interest, I am one of them, please allow me to represent them. Okay. Now B part says that suppose there is a litigation before the court, or there are various suits before the court, or there are various suits spread in different courts in a particular district. Okay. And it is found that many of these suits consist or concern numerous persons, okay, who have same interest. You know, we find that many a times there are suits which are identical, suits for the same cause of action, suits by different persons with the same relief which are being filed, and they are conducted separately. Trials are held, judgments are given, and sometimes even inconsistent judgments are given. Now, to avoid that, 8B says even the courts have power. They are given suo motu power. Suppose parties don't apply. If the courts think that, well, there are suits or there is a suit where there are numerous persons, they have the same interest, court can direct that one of them will represent, okay, the other plaintiffs or other defendants. Now, therefore, there are two parts. One, party can do this. Second, the courts are also suo motu given this power. Now, please note that here, while doing so, consent of the defendant is not necessary, or consent of the plaintiff is not necessary. It is for the court to see if there are numerous persons and same interest, the court can exercise its powers. Then let us go to the second part of Order 128. It says that, and this is, it should be noted that, see, Order 128 is a self-contained code. It's a code by itself. So we have to scrupulously follow the provisions because it has a far-reaching impact. The second part of the provision says that the court shall, in every case where a permission or direction is given under Subrule 1, at the plaintiff's expense or defendant's expense, as the case may be, give notice of institution of the suit to all persons so interested, either by personal service or where by reason of the number of persons or any other cause, such service is not reasonably practicable by public advertisement as the court in each case may direct. Second part of the provision says, okay, you have applied, the court has permitted you, or the court suo motu decides that this suit is to be converted into a representative suit. Now, the second step is that if it is possible, if there are parties who are not parties to the suit, either a plaintiff or defendant, issue them notices. Tell them what is it, briefly, what is the plaint about, what is your right, what is your injury or grievance, which is okay. If practicable, try to reach out to them. But if it's not practicable, because there can be a group which you may not be able to reach by direct notices, then it says by public advertisement. Okay. In today's world, even social media can come in, emails can come in, etc. It is important that a public advertisement is issued, and that public advertisement is issued in a newspaper of wide circulation so that it reaches maximum number of people, and all those who are interested, who wish to come, can come and join. Okay. Now, this advertisement also has a great impact on the litigation for the simple reason that the moment you advertise like this, the plaintiff or defendant, if you are a plaintiff, the defendant, if you are a defendant, a plaintiff, is going to be alarmed, because now the scope of the suit is going to be very, very, very wide. And let me tell you, I will deal with it when I come to the United States experience, that most of the times in US, the moment public advertisement like this is issued, matters are settled and compromised, because corporate giants, people do not wish to face a litigation consisting of numerous persons, because the stakes and the results can be devastating for one of the parties. So many times you will find that a settlement takes place immediately after the advertisement is issued. Then the third part of Order 128, it says, any person on whose behalf or for whose benefit a suit is instituted or defended under Subrule 1 may apply to the court to be made a party to such suit. So after advertisement or after notice, any party who wishes to join can apply to the court, well, I'm interested, please make me a party. They are allowed. There may be people who, in spite of notice, in spite of knowledge, may not join. That is fine too. But our procedure says that you have informed them. They haven't come. It is their choice. I will come to it little later as to what will be the impact on the people who actually do not join. That also is provided under Order 128. Fourth part says that no part of the claim in any such suit shall be abandoned, okay, or withdrawn or compromised, okay, unless again a notice is issued, as we have seen, to all persons or by advertisement. And if you read Order 23 Rule 3B, it specially provides that permission of the court is a must for withdrawal, abandonment, settlement, or compromise of a representative suit. Okay. There are two reasons why this provision is made. One is, see, this type of a litigation, a lot of control is given to the court in the interest of numerous persons. So it is necessary that sometimes it may happen that because of the impact, only some people may enter into a compromise and go away, and the others may not agree with that compromise, or the court may not know of the impact of it, and the compromise may affect a large number of people. To avoid that, two things are made necessary. One, again, a notice must be issued if you want to compromise or withdraw or abandon, so that those who wish to take objection can take objection. The court will consider them. And second, without the permission of the court, especially without the permission of the court, such withdrawal, such abandonment, such compromise will not be allowed. Okay. Now, fifth part of the provision says, where any person suing or defending in any such suit does not proceed with due diligence in the suit or defense, the court may substitute in his place any other person having the same interest in the suit. Sometimes it may be that the court appoints or the court allows some persons to be representatives of others, okay, or court allows one or more people, one or more lawyer to be representatives as lead litigator or lead lawyers, as we say, okay. And later on, it is found out by other parties or the court that they are not litigating with due diligence. They are not litigating the way normal litigant would do in his or her own case. In which case, again, the court is given a power to substitute that plaintiff or defendant with others. So the court, again, there's a lot of control which is there in the hands of the court. Last part of Order 108, Sub-Rule 6 says, a decree passed in a suit under this rule shall be binding on all persons on whose behalf or for whose benefit the suit is instituted or defended, as the case may be. Now, this is another crucial sub-rule. And if you read this sub-rule with Section 11, Explanation 6, the result is that once a judgment comes, after decision on issues, it acts as res judicata against all members of that class. Now, this is a far-reaching provision that principles of res judicata are attracted once a decree is passed, and that's exactly why all these requirements of public notice, all these requirements of advertisement in a widely circulated newspaper have to be scrupulously followed, and the control of the court has to be there. Lastly, as far as this provision is concerned, there was, before the amendment in 1976, some debate as to what is the meaning of the term same interest. So, numerous persons, same interest. What is same interest? Some courts had interpreted that same interest means same cause of action. Okay. And some courts had interpreted the same interest need not be same cause of action, because two people may have same interest but may not have same cause of action. Now, an explanation is added in 1976, and I will read the explanation. It says, for the purposes of determining whether the persons who sue or sued or defend have the same interest in one suit, it is not necessary to establish that such persons have the same cause of action as a person on whose behalf or for whose benefit they sue or are sued or defend the suit, as the case may be. Simple words, same interest does not mean same cause of action. Cause of action can be different because every person will have his or her own cause of action, but the interest can be same. So again, a very wide meaning is given. Same interest does not mean same cause of action. Okay. We will come in more details as we go on. Now, just a few things about this entire Order 108. If you read Order 1 CPC, the normal rule, Rule 1, Rule 3, who can be plaintiffs, who can be defendants. Rule 10, joinder of parties. All of this will tell you that normal rule is that all persons in a suit who will be affected must be made parties. Rule 1, Rule 3, Rule 10, etc. Now, Order 1, Rule 8 is an exception to Order 1, Rule 1 and Rule 3. It's a special provision. Okay. Then there is also, if we see some other rules also under Order 1, if you see Order 1 rule, we will just concentrate only on Order 1. Order 1 rule, yes. If we see Order 1, Rule 3A, okay, it gives power to order separate trials where joinder of defendants may embarrass or delay a trial. 3A. Important 8A. Power of court to permit a person or body of persons to present opinion or take part in the proceeding. Now, this is also rarely used, but in representative suits, 8A can be used, and the court can call upon any person or body of persons to present opinion and take part in the proceedings. Am I audible? I'm audible. Yeah. Okay. Then one other important provision which is rarely used in civil courts, but it's used in the high courts all the time. Rule 10A is about amicus curiae. Court can invite lawyers of eminence to assist it as friend of court in a particular matter. Now, this can be done in Order 1, Rule 8, because there you will need assistance of good lawyers, senior lawyers. That is there in Rule 10A. So, all these rules can be used in Order 1, Rule 8, but keep in mind that Order 1, Rule 8 is an exception to Rule 3 and Rule 1. Is an exception to the general rule in CPC. Object is where large body of persons are interested, but not all of them can be made a party, you use Order 1, Rule 8. But of course, we will have to keep in mind 3 parameters. 1, all those persons must have a right or a liability if they are going to be defendants or plaintiffs, as the case may be. 2, there must be injury or grievance resulting from breach. Okay, injury or grievance. So, that is what is a requirement of a civil suit, civil right. And 3rd, relief claim. So, you must show that in a particular proceeding, the numerous persons have a right or liability. They have injury or grievance resulting from any breach, and they are the same. So, the parameters which are to be used for applying Order 1, Rule 8 would be these 3. Now, though Civil Procedure Code is that way, a procedural code, many of the provisions, or at least some of them, are not merely procedural. They are substantive as well as procedural. If you see Order 1, Rule 8, it is just not procedural, it is substantive as well. Why? Because see, for the first time, a right is created in numerous persons having same interest. This is a substantive provision. And thereafter, the procedure is laid down. Okay. So there are principles of law, there is substantive law which is involved, and also procedural law under Order 1, Rule 8. It's a self-contained code. There are certain provisions in CPC like Order 7, Rule 11, where rejection of plea. There is no other provision in CPC from where you can get guidance about rejection of plea. Similarly, Order 1, Rule 8 is a self-contained code. Every question that you may have relating to representative suits will be answered under Order 1, Rule 8. It is very clear provision. It really does not need much interpretation. So, it's a self-contained code. As I said, court is given control over the litigation, and therefore, participative justice is what is the aim of Order 1, Rule 8. The litigation will not abate on death of any party. Again, the interpretation which has been made by the courts, the apex court to which I will come, is that what is to be seen is what is common in a class and not what is different in the people. So the interpretation is to see what is common and not what is uncommon. Okay, these are some basic things about representative suits. Now I will take you to section 91 of CPC. Now, if we see section 91 of CPC, okay, it is about public nuisances and other wrongful acts. Okay, and it's a small provision, so we will read it. It says, and this was also amended in 1976. In the case of a public nuisance or other wrongful act, now these words are very important. It says not only public nuisance, it says other wrongful act. Okay, so see, a very wide import is given to this provision as well. Public nuisance as well as any wrongful act affecting or likely to affect the public. Now here the condition is that it must affect the public, not a particular class. So this has to be distinguished from Order 1 Rule 8. Not a class, but a public. A suit for declaration and injunction or for such other relief may be filed or may be instituted. But, so again, I'll repeat, two things: public nuisance, wrongful act affecting the public. Now, this suit can be instituted. There are two conditions. One, by the Advocate General. So you may have to approach the Advocate General. Advocate General will have to be convinced that there is a case of public nuisance. It's a wrongful act affecting public, and then the Advocate General is authorized to file the proceeding in a civil court. Okay. In practice, you know, this may not happen. Now, therefore, they have also given another option. With the leave of the court, again, two or more persons, though no spatial damage is shown by them, can be allowed by the court to file such a suit. So either you approach the Advocate General or you approach the court. You apply to the court that you are a member of this particular public nuisance you are facing. You are part of the affected person against this public nuisance or any other wrongful act, and the court should allow you to file a suit under section 91. Now, if the court is convinced that that you are the member of the public, one, that you are affected, two, that what you are representing is a public cause, that is a wrongful act or a public nuisance, then the court will allow you to file a suit under section 91. Now, section 91, subsection 2 makes it clear that this provision will not limit a right to file a suit which may exist otherwise than section 91, which means Order 1 Rule 8, if you want to file as a class, it has obvious advantages, you may do so. If you want to come under 91, you may do so. So depending on what is your tech, you can go under Order 1 Rule 8 or under section 91. If we compare representative suits with section 91 suits, I think a few distinctions can be made. One, in representative suits, same interest and numerous persons, but a class is defined. In section 91, it need not be. It is for a public. Representative suits, spatial damage has to be shown. Section 91, spatial damage need not be shown. The very fact that you are the member of the public is sufficient. Section Order 1 Rule 8, representative suits are given wide meaning. There is wide scope, and it need affect only a class. While public nuisance or other wrongful act affecting or likely to affect the public, the court will be cautious because you are coming as a member of public. Here, Order 1 Rule 8 will be like a regular civil suit where normally permission will be easily given. Section 91, the court will really inquire into the cause and only when satisfied will give you the permission. So representative suits leave will be given as of right, but section 91, one has to convince the court. Now, since we are using the words public nuisance, let us understand what public nuisance means. Public nuisance is not a term which is defined anywhere in the court, civil procedure. Therefore, as we always do, we have to go to the General Clauses Act. Now, section 3, subsection 48 of the General Clauses Act says that public nuisance, wherever the word public nuisance is used in any legislation, go to Indian Penal Code. Okay, so even for civil purposes, you have to go to Indian Penal Code through General Clauses Act. And section 268 of the Indian Penal Code says public nuisance is injury, danger, or annoyance to the public, or to the people in general who occupy the property in the vicinity or who use any public right. So any injury, danger, or annoyance to the public is what Section 91 says. So now, see, I have tried to bring forth what is a representative suit, what is a Section 91 proceeding. Before I go into how, coming to the topic as to how this can substitute PIL, I think we need to understand what PIL is, and then we can come back and see how this can substitute a PIL. So let us see what a public interest litigation is. My next slide is just about the topic. Now, public interest litigation. This country is one of the perhaps the only countries of the world where public interest litigation or social action litigation has developed in last from, you can say, 80s onwards. Justice Bhagwati, Justice Krishna Iyer, and so on and so forth. Now, if you analyze public interest litigation, you will find that there are two types of public interest litigation. One, a member of a public for a public cause will go to High Court under Article 226 or to the Supreme Court under Article 32. The member of the public will invoke 226 or 32. That is one way of approaching it as a member of the public because it is affecting public at large. Second way of a public interest litigation is that you may not be even a member of that group, that public, that class, but because those people, for reasons of poverty, for reasons of being a disadvantaged group, disability, children, women, prisoners, slum dwellers, etc., the list can go on. They are unable to come to the court. So you say that, please, I have come to the court, either yourself or an NGO or an organization, please allow me access, not for my own benefit. I am not a part of that class, but for the benefit of those who are affected due to normally PIL, government lawlessness. So this is another way in which public interest litigation can come up. Third also, which is of course part of number two, sometimes though nobody comes to the court, somebody writes a letter to the Chief Justice of the High Court or the Supreme Court. That letter can be converted, and it has been converted in some cases, into a PIL, and the court appoints lawyers and asks the lawyers to draft a petition, notices are issued, and a PIL is formed and the PIL continues. Sometimes not even a letter. The court, the judges read newspaper reports, and those newspaper reports are converted into a PIL, notices are issued, and a PIL starts. So here, mind you, the concept of locus standi, which we have learned in our law schools, that if you want to go to a court, you must be affected. You cannot take up somebody else's cause, has been diluted, has been read down to help disadvantaged people, poor people, because of the socio-economic conditions in a country like India. Now, this is in brief what PIL is. PIL can be a topic by itself, but just for our purposes to understand what PIL is. Now, keep in mind that if you are going under Article 226, it is not only relief relating to fundamental rights, it can be any other relief. If you are going under Article 32, relief relating to violation of fundamental rights. Now, let us keep in mind that this is what public interest litigation is, and as you know, I'm sure all of you must have read a lot about PIL. The way Indian courts have encouraged PIL is by very innovative and creative use of two articles Really, first is Article 14, right to equality, and Article 21, right to life. Okay, the right to life and the meaning of right to life is expanded by the courts for giving justice to people so much that life does not only mean living and dying. Life means all that is necessary for comfortable living. So now you can imagine a lot of things can come in. Environment will come in, education will come in, and so on and so forth. So Article 14 and 21 have been used very creatively and innovatively by our higher courts. So they have included accused persons, contract laborers, bonded laborers, women, children, disabled people, slum dwellers, public at large, particularly into environmental related issues. If you have gone through those MC Mehta cases, you will understand this. I will not go, because PIL can be a topic by itself. Dr. Upendra Bakshi, one of the great jurists, after, though he's very critical of PILs, and also my own guide for PhD, Dr. Satyaranjan Sake, though PIL does have a place, I will come to what are its problems and some criticisms of PIL. But Dr. Upendra Bakshi has gone on record and said that initially the Supreme Court of India was not the Supreme Court of India for Indians. It was Supreme Court of India only for the haves. But because of PIL, and I quote Dr. Bakshi, he says, the Supreme Court of India is at long last becoming, after 30 years of the Republic, the Supreme Court for Indians. So Dr. Bakshi says that now because of PIL, the Supreme Court is really becoming Supreme Court for Indians, which it was not for the 30 years. Okay. Anyway, so this is, we will now again go back to our topic. This was to introduce you to what PIL is. Let us keep in mind what are representative suits, what are public nuisance suits, what is PIL. And now I will take you to the categories of representative suits. And you will yourself understand, I'm sure, that a lot of PIL, which was done in higher courts, in high courts, in Supreme Courts, could very well have been done under Order 108, civil courts, or under Section 91. When I read in limited time, I may not be able to give you all the cases, but 452. Okay. All right. But I will just read the categories of representative suits. Okay. Though, as I say, the provision is not used as much as it can be, the potential it has, but there are precedents. And I will just read the categories of cases where a representative suit has been used in this country. The categories are like these, and I have rulings on each of the category. I won't take your time in giving the citations. I can hand them over to Advocate Priyanka. 1. Suits to enforce religious rights or rights of people belonging to a particular caste or community. So in this country, suits relating to particular caste or community, suits to set aside alienation of temple property by worshippers, suits relating to right to procession. So all those rights which can be called as religious rights, which relate to its office, okay, which relates to right of worship, which relate to a particular caste, a community, property relating to temple, etc. All these can be brought in Order 1, Rule 8. Okay, but here, you will immediately, just to give you two recent examples, we have seen that Sabrimala happened by way of a constitutional case, which in fact could even have been tried by leading evidence under Order 1 Rule 8. Even recently, I was told that a couple of days back, Jain community went to High Court because I think today is the auspicious day for Jains, that for Paryushan Parv, the courts should allow them to open the temples and they should be allowed to visit the temples. Now, they went in constitutional jurisdiction in the High Court. High Court issued notice to the state government, and the state government said, no, this cannot be done because of COVID situation, and the High Court refused to leave. Now, this could also have been done under Order 1 Rule 8. Right. Anyway, suit. In fact, this reminds me that there is a reported ruling of our High Court that some years back, a person from Jain community went to court and he said that Amul cheese, which is being sold, they sell it under the category that it's a vegetarian product. But it was his contention that it was not vegetarian. It contained some part which is non-vegetarian. And therefore, according to him, this was a misleading advertisement and it must be stopped. And he applied to the court for making this into a representative suit as representing the entire Jain community. And our High Court, in a judgment which is reported, I will give you the citation of that judgment, which is AR 1983 Bombay, page 66. It's a judgment of Justice Dharmadhikari, Justice Chandrasekhar Dharmadhikari, allowed a representative suit of this type. Then, suit to establish or negative public rights. There are so many public rights like right of way, right to use well, right of path, etc., of villagers, of city people, relating to environment. Okay, all these public rights can be brought under Order 108. Of course, you will have to show that there is a spatial damage to you. So pathways, wells, ghats, fisheries, etc. can come. Then major chunk. We find that many a times petitions are filed in the High Court and Supreme Court against government bodies, semi-government bodies, municipal corporations. Here, if you are a taxpayer of a municipality, okay, you can challenge the actions of municipality in class action, as a class action under Order 108, relating to all municipal services and all alleged violations against corporations, against government, against semi-government bodies. You need not at all go to and invoke constitutional jurisdiction. So this is possible. Investors and depositors, and I will come to some rulings in this respect. Allottees of housing boards or common tenants. There have been cases where representative suits have been filed in these categories. Now, let me tell you that these categories are not all, they are not exhaustive. And this is why I said that in the beginning, it depends on the innovativeness and creativity which we will show. The bar and the bench will show. They have already shown it in PIL. Now it's time we show it in encouraging representative suits and public nuisance suits. I will just give you a few landmark judgments and then take it further, because I think I should not exceed the time as well. Let me start with an English case, the Duke of Bedford versus Ellis, where where House of Lords allowed fruit growers, okay, agreed by the acts of Duke in denying their rights and relief, being beneficial to all the growers. They allowed a class action, though each grower was different. They allowed a class action against the Duke for the first time in English history. Then coming to Supreme Court, the Supreme Court in a judgment reported in AR 1990 Supreme Court, which is a landmark judgment, Chairman Tamil Nadu Housing Board Madras versus T.N. Ganpati, where numerous allottees under the housing scheme were allowed to file a representative suit because a demand was made by the housing board against them, and they all wanted to challenge that. Another landmark judgment is of Municipal Council Udupi, AR 1974 Supreme Court 2177, where illegal construction of cinema building in a residential area, it was observed that challenge to the resolution of municipal corporation could be made under Order 128. Then, more interestingly and recently, in 2017, though a suit came to be filed by non-promoter shareholders of Tata Group companies, challenging ouster of Mr. Cyrus Mistry from Tata Group as executive chairman. It was held by our High Court. It's a judgment of Honorable Justice Gupte, where he says that here there is a sharp division amongst the shareholders. Some shareholders want Cyrus Mistry, some shareholders do not want it, and therefore he did not allow a representative suit. So there are many, but the judgment lays down how a representative suit can be filed and how it can be encouraged. In my view, therefore, I don't know why for local problems, let's take Corona. Now, any problem relating to Corona, people are rushing to High Court or Supreme Court and invoking the jurisdiction of High Court or Supreme Court. In fact, problems of each area, even relating to Corona in this country, are different. You can't take your local problems to Delhi because Delhi is not going to understand what your local problems are. You must go to your local courts and seek remedy. But unfortunately, maybe due to lack of awareness and also that higher courts entertain, and though we will see that in many of the petitions in High Court or Supreme Court, the courts tell the people go and file a civil suit. Many times that doesn't happen, and the remedy is lost because in a writ petition, as we all know, disputed questions of facts cannot be taken, and if it becomes a question of taking evidence, petitions are not encouraged. Many times what happens is these petitions are dismissed, because of which now you cannot come to a lower court and file a proceeding because High Court has already dismissed the petition, unless the High Court has given you a liberty or High Court has made it very clear that since there are questions of evidence, go to the civil court. So it is necessary that even higher courts take cognizance of these provisions and allow people and encourage people to go to local courts. So many problems relating to education. Now, a matter is pending in the Supreme Court about whether examination of the last year is to be held or not. Now, again, here the problem can be localized depending on a particular locality, and problem could have been brought in the local courts. Problems relating to against government, municipal corporations, public causes are often taken up in PIL, and that results in these remedies getting unnoticed. Now, therefore, to tell you the scope of representative suits, I would take you, next slide, can we have the next slide? Tell you that scope of representative suits is the scope of Section 9 of CPC. And Section 9 of CPC says that the courts shall have jurisdiction to try all suits of a civil nature, okay, unless they are expressly or impliedly barred. If there is a bar in law, then it's different. Otherwise, all civil suits, all rights of civil nature can come under Section 9 CPC, can come under civil court, and therefore can also come under Order 1 lay. Okay. Now see, next slide. Please note that legal thinking is always influenced by procedure. Don't think that it is only having substantive law is sufficient. Procedure is sometimes more important than substantive law. So it is always influenced by substantive law. In a landmark judgment, 1955 Supreme Court, Justice Bose, in fact, has, and since then there are many judgments where it is said that Civil Procedure Code is a procedural code. Okay, it is a code designated to facilitate justice and further its ends, and therefore it should be used not technically, but should be used in a very flexible manner so that justice is brought to people. This is where legal thinking is always influenced by people. And again, going back to Krishna Iyer, he says in Ratlam Municipal Council, he says it is procedural rules which infuse life into substantive rights. So procedural rules are as important as substantive rights. Let me just take a detour next. Just briefly, position in United States. In United States, you will find that there are similarities. First of all, there are a number of similarities in our legal system, though socioeconomic conditions are different. Okay, we follow common law. They do. They also have civil law, etc., etc. There is Federal Rule 23, which many states have adopted, which is similar to our Order 1 Rule 8. And you will find that class actions are a very powerful tool in US. They do not go to Supreme Court for their class matters. They go to federal courts or state courts, as the case may be. And therefore, you will find that civil rights, public rights, consumer rights, licensing, environmental law, product liability, school litigation, investors, mass tort actions are all brought in the US in the lower courts only. For paucity of time, I will not go into the US, but it is one of the most powerful tools. In fact, the moment a class action litigation is filed, many a times the other side, if you go into that material, smoking companies, tobacco manufacturing companies, etc., surrender and settle the claims because they know the impact of class actions. Now, let me tell you, let us go to why I advocate representative suits. For that, let us see what are the criticisms of PIL. Next. Now, PIL has its own problems and criticisms. The first is, as we all know, and there is always a contention against PIL, that the judges, through judicial activism, are encroaching on the branches of legislation and executive. Second, judges are trying to reform the society, which is not their task. Third, and Alexander Bickel has a book called Least Dangerous Branch. Here he says this type of a work of judges is anti-democratic and counter-majoritarian, because judges are not elected, they are selected. So it is anti-democratic and counter-majoritarian. Many a times we find that private litigation is converted into a PIL and it is encouraged for private motives. It's, after all, constitutional remedies are extraordinary remedies. They are not to be used routinely. PIL has also become a populist litigation. We see that, though there are cases which are 20 years, 25 years old, they are sidetracked, and a PIL comes, the PIL is entertained immediately. Now, this has therefore become a populist litigation. Dr. Bakshi again says that PIL is nothing but cripping jurisdiction of the court, by which it means that the courts, particularly you will find that in environmental matters, the court passes orders, but the court has no way in which the court will really get into the implementation of it in its completeness. Therefore, passing orders for the sake of passing orders, where the courts cannot ensure its compliance, I think is not at all good for the courts, because that will hamper the very sanctity of the courts and very sanctity of entertaining any petition. So the courts, it's difficult for the courts to control a PIL and a litigation relating PIL. Many a times, see, governments know their priorities best, but the judges, when a particular matter comes before them, let's say of a disabled person, give so much funds to disabled people, okay, the courts are not aware of the government priorities, and maybe there may be a group which is more in need of money than disabled people, but the court, since that group is not before the court, ignores it and passes order only in respect of a particular group. So it is not the task of the court to decide the priorities. Again, no evidence is taken, so questions of fact are not decided, which can be decided in civil courts, and also interim reliefs can be passed in civil courts. In all, the answer to the problems in this country do not lie in PIL, they lie in political process and encouraging civil litigation at lower courts. And they do not, the courts think that they can deal with all the problems, social economic problems of this country, but that is not the ultimate answer. Answer has to come through a proper political process. Now, let me just point out major advantages of representative suits. Why representative suits? One, it brings in, as I read in the beginning, in the preamble to the Constitution, social, economic, and political justice to our people at local levels. It will give greater access to justice, Article 39A. Collectivization of resources of a group. Here, since the resources of a group are collectivized, even a poor person who otherwise will not be able to sustain a litigation, since he is combined with many others, resources will be combined. You can have even lead senior lawyers represent a group. Okay, so collectivization of resources of a group is a major advantage. And to just give you a small example, suppose there is a very small injustice which is done to us in a consumer jurisdiction. We go buy a toothpaste. We find that the toothpaste says 200 gram, but it's actually 150 gram. Now, you are not going to go to consumer forum or the court for the purpose of those 50 grams. But if you go to a court and invite all those who are misled or who are cheated in this manner to join in a class action, you can see the impact. And then collectivization of resources will result in even a mighty corporate giant surrendering. Uniformity, economies of time, money, and energy. Okay, number of a huge litigation or number of suits can be combined and decided. So economies of time, money, and energy. Uniformity of decisions as to persons similarly situated. It will also act as a deterrence against illegal behavior. See, people who behave illegally know that you won't go to local courts and you won't immediately have legal redressal, access to justice. That's why they continue. Once they know that you can go to local courts and local courts will pass orders against them, it will act as a deterrent against illegal behavior, because they know reaching the high courts and Supreme Courts is not that easy. Delhi bahut dur hai. Then enforcement of government policies and laws through litigation. And this will also lead to development of substantive areas of law, which otherwise have not, through innovativeness and creativity of jurists, of lawyers and judges. There are, in number of PILs, the judges themselves have observed that there is need for thinking about civil suits, about class actions, about Order 1 Rule 8. Just to quote a jurist, V.S. Deshpande, he says, it would not be correct to say that a high court is bound to entertain a writ which is in contravention of fundamental right. The enforcement of fundamental rights is not restricted to Article 226 and 227. On the contrary, the ordinary civil courts constitute primary forum even for enforcement of fundamental rights. Under Section 9 of CPC, every right of a civil nature is enforceable by suit out of the cause of action of a civil nature. Then in a 1983 judgment of Supreme Court, Justice Fazal Ali and Venkat Ramaiah, they have framed 10 questions, and they have said that these must be answered by a constitutional bench. They are not yet answered. And 2 of those questions are like this. 1, can this court take action in matters for which remedy can be had in ordinary civil, criminal, or revenue courts, or other officers on the ground, or other officers on the ground that a number of people are affected? 2, if this court can take action on laters in informal way, why should not the high courts and other courts, authorities and officers in India also act in the same way? So they have said PILs, why not PILs in the manner in which representative suits can be filed? Why not PILs at local courts as was done under Article 226, 227 and 32. Now, I think the last part of my talk is, therefore, how do we go about this? What are the problems? What are the remedies? How would we encourage representative suits, class actions, Section 91 suits? So problems and remedies. One is, and I think effort of Vasantrao Patil Training Center is an effort in this direction, is spread of awareness. Unfortunately, I see litigants, lawyers, judges are not well aware of these provisions and the use and the precedents which are there under these provisions. So spread of awareness is the first task. Second, we may have to train lawyers and judges as to how to handle a class action litigation. 3, we have to also encourage these types of remedies in our legal education. Even in legal education, a lot of emphasis is given on PIL and not on these remedies. I would say that, in fact, Vasantrao Patil Training Institute, which is one of the, perhaps the only institute in Maharashtra I have seen, which is doing such a great task, can take lead in this and can actually identify public causes like these and see if the institute can support litigation of this type. I think that will go a long way for social and legal reform. So I think that is possible. Okay. in a lighter vein, I know all of you are are because of lockdown are getting bored. Let me tell you that this remedy is so very popular in United States. There is a movie called Class Action. So those of you who are interested can watch that movie. It's a class action movie. It's a 20th Century Fox production directed by Michael Apted. It stars Gene Hackman, Mary Elizabeth, and Master Antonio. Beautiful movie. So those of you who are interested can actually see how class action is can be handled and is handled in US. So that's something which is a motion picture which you can see. My effort is what Lord Denning has said in Pecker versus Pecker. You can see Lord Denning. An argument was made before him in a case that what is the that a case came and an argument was made which was novel, which was innovative, which was creative, which was never made before. The other side objected that this has never been done before. How can we do this? And this is the answer of Lord Denning. What is the argument on the other side? Only this, that no case has been found in which it has not been done before. That argument does not appeal to me in the least. If we never do anything which has not been done before, we shall never get anywhere. The law will stand still while the rest of the world goes on, and that will be bad for both. So what we need is creativity. What you need is innovativeness, and the provision is very, very much there. It is not that we are going in a fashion where there is no legal base. So I think I have made my theme very clear that representative suits, class actions, Section 91 suits are a substitute for PIL. They need to be encouraged and thought about. Finally, I would like to thank everyone. As Winston Churchill says, courage is what it takes to stand up and speak. So though, because of webinar, I'm not standing up and speaking, but I'm speaking. But courage is also what it takes to sit down and listen. So I thank everybody who is sitting down and listening to me. I hope I made my point clear. If there are any questions, I will be happy to take them. Thank you very much, all the organizers, all those who have joined this webinar.
Thank you so much, sir. It was a very insightful session. And I would also like to thank you for your kindness for highlighting our institution. It is only because of advocates like you who come and make our institution more proud. And it is just an honor for us to have you here, sir. Sir, I would like to ask a couple of questions with regards to today's topic, sir. With your permission, may I please start?
Yes, please.
Okay. So the first question is from Advocate Pramod Suthar, who's from Sangli. He asks, with reference to the bail of under trial prisoners who are COVID positive, can one take class action like PIL through District Legal Aid Committee or Jail Authority?
Okay, now see, this is where the problem is. Even lawyers immediately ask questions whether a PIL can be filed. I think after my lecture now, the question should be whether a representative suit or a class action can be filed. Okay, so I think the focus should be when PILs can be filed. But now we will also see if Section 91 or Order 1 Rule 8 suit can be filed. I think Advocate Suthar, if you are going and representing people, okay, think of 1/8, take one of them or two of them as representatives, file a class action, okay, show to the court that there is an injury to their right and claim a relief if that is the case. If they are members of public, then go under Section 91. Why think of PIL? That is my answer.
Okay, sir. Noted, sir. Thank you so much. So the next question is, what is the court fee for filing such representative suits? This is asked by Advocate Pramod Agarwal.
Yeah, I think I have explained this court procedure is what his question is, right?
His question is, what is the court fee for filing such a representative suit?
What is the court fee? Okay. Yes. Court fee will be the same as is applicable to any civil suit. There will not be any special, there is no special category in the Court Fees Act for representative suits. So in fact, you can collectively bring the money of all the people together and pay the same court fee. And as we know, in the there is a ceiling of 3 lakhs for civil suits.
Thank you, sir. So the next question is asked by Professor Deepa Vagyani, and she asks, Indian judiciary made to flourish PIL, whereas reluctant to file class suits? For example, Bhopal gas tragedy compensation matter. Do you agree, sir?
Yeah. Actually, this is a very Professor Baghani, Deepa Baghani has asked a very good question. In fact, Bhopal gas leak disaster was is perhaps the best example where class action could have been used. But see, we made a chaos out of it. After the disaster, class actions were filed in the US. US courts said the jurisdiction is in India because the company is Indian. And in India, class action suits were filed. But government passed a legislation, took up the claims of people as parents patriae. And then the government entered into a compromise with Bhopal gas leak, with Union Carbide. And out of that, some amount is reported in the Supreme Court, some amount is still not paid. So it's a chaos. If we were well equipped to convert this into a good class action, a good litigation through a good judge and a good bar, I think it would have been really one of the best examples which India could have been given. And in US, similar mass tort class actions like Agent Orange or school asbestos, etc., are handled and reliefs are given to people. So I think this is a very good question. Bhopal gas disaster is a lost opportunity for class action.
Noted, sir. Thank you, sir. So the next question is asked by Shrikant Bogle, and he asked, can a class action lawsuit be filed against the state government or union government? Can you give us a few illustrations?
Yeah, I think definitely yes. If you have a civil right which is infringed, you can go against governmental machinery, semi-government, Union of India, state government. There is no civil. See, understand Section 9 of CPC, your civil right is infringed, you can go against anybody. There is no bar. Okay. I think I have given a number of examples in which municipal corporations, governments were sued under representative capacity.
Okay, sir. Thank you. So the next question is a bit elaborated. Please bear with me. A class may dispute an agreement which causes an appreciable adverse effect on the competition within India or abuse of dominant position by an enterprise. Whether under these circumstances, a class action suit be filed under Competition Act by a consumer.
Yes, now the Competition Act does provide for class actions. So definitely, yes, class actions can be filed under Competition Act as well. That's why in the beginning I said that there are other legislation under which also class actions can be filed. But my focus was mainly on civil court vis-a-vis PI. Yeah, but you are right.
Yes,
it can be filed even under other legislation.
Yes, sir. So the next question is, class action suits are recognized by most countries in the world, where consumers or affected parties can pursue a common course of action. Whether these class action suits can be filed in respect of a wide variety of claims concerning consumer protection, environmental law, securities regulation, amongst the other things here in the trial courts or tribunals in India.
Yes, of course. As I mentioned, in Consumer Protection Act, the old repealed acts as well as 2019 Act, they have specially provided that one person can sue or can file a complaint on behalf of numerous persons having same interest. And in consumer jurisdiction, there is a wide scope to file these types of complaints against unfair trade practices, defect in goods, deficiency in services. So there is great scope under consumer jurisdiction also. Yes, very much.
Thank you so much for being patient and answering these questions, sir. I would now hand over to Abhinandar, sir, for delivering a vote of thanks. Thank you so much, sir.
I think Abhinandan sir has some connectivity issues. So thank you so much, Santosh Shah sir, for that insightful lecture. And as you rightly pointed out, that there needs to be an awareness about this class action, and this needs to be instilled right and in the education system where you learn law and the awareness about the same needs to be dealt with at all levels. And we, the Vasantrao Patil Lawyers Training Center, through our innovative ways, will definitely give it a try as per your suggestion, if we can support it in a big way. Thanks for the wonderful representation, sir. You made it sound so simple, and we have been receiving awesome feedback for your lecture, because it was so informative, it was so insightful, and I've heard you before also, so I wanted you on a bigger platform where you can reach out to a lot many people. And we are looking forward to you, sir, to have you on our platform again and again with such kind of innovative and informative topics. I would like to thank everyone who has participated in this webinar, the technical team, and a special thank you to you, sir, for making such an impactful lecture. And thank you once again on behalf of Vasantrao Patil Lawyers Training Center and Sangli Bar Association.
Thank you. It was a pleasure.
Thank you, sir. With your kind permission, may I declare this webinar to have been concluded?
Yes. Thank you so much.